Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. The regulations surrounding retirement accounts and marital dissolution are complex and subject to change based on federal law and individual state jurisdictions. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified attorney or certified financial planner before making any decisions regarding their personal assets. Imagine working for 40 years, meticulously diverting a portion of every paycheck into a locked vault, watching the compound interest turn modest savings into a seven-figure nest egg, only to realize that a single signature on a divorce decree can slice that lifetime of discipline in half in a matter of seconds. In the United States, the 401k is often the single largest asset a family owns, sometimes even eclipsing the equity in the family home. Yet, most Americans treat it as an untouchable personal fortress until the moment the legal papers are served. We are currently witnessing a massive historical shift where the intersection of retirement security and marital collapse is creating a new class of financial reality. This is the story of how a tax code loophole from 1978 became the primary battlefield for modern American divorce, and why the golden years are increasingly being split down the middle before they even begin. This masterclass is designed to provide you with a deep understanding of the cultural and legal evolution of the 401k within the context of American divorce. By the end of this series, you will understand the historical shift from traditional pensions to self-directed savings, the mechanics of how these assets are actually divided, and the potential outcomes that many people overlook until it is far too late. We are solving the mystery of the Qualified Domestic Relations Order and exploring why the modern American retirement system has made divorce more mathematically complex than at any other point in our nation's history. To understand where we are, we have to look back at the late 1970s. Before the 401k existed, the American dream was built on the back of the defined benefit plan, or the traditional pension. If a couple divorced in 1965, the pension stayed with the worker, and the spouse often had very little legal claim to those future monthly checks. The system was rigid, but it was predictable. Then came the Revenue Act of 1978. Section 401k was tucked into the tax code almost as an afterthought, intended to give executives a way to defer some of their bonuses. Nobody at the time predicted that this minor provision would eventually dismantle the pension system and place the entire burden of retirement saving onto the individual. As companies realized they could shift the risk of market fluctuations from their own balance sheets onto their employees, the 401k exploded in popularity. By the 1990s, it was the gold standard for American savings. However, this shift created a massive legal vacuum. Unlike a pension, which is a promise of future income, a 401k is a liquid, growing pool of cash and securities. When a marriage ends, this pool of money isn't just a number on a screen. It represents years of shared sacrifice. If one spouse stayed home to raise children while the other contributed to their 401k, who does that money belong to? The law had to evolve rapidly to catch up with this new financial architecture. We have to examine the concept of community property versus equitable distribution. In states like California or Texas, the law generally views any wealth built during the marriage as a 50-50 split, regardless of whose name is on the account statement. In equitable distribution states, the split might not be exactly equal. It is based on what the court deems fair. This creates a high-stakes environment where every dollar contributed between the wedding date and the separation date is scrutinized. For example, if an individual entered a marriage with $50,000 in their 401k and exited it 10 years later with $500,000, the court doesn't just look at the final number. They have to perform a forensic accounting of the growth, the contributions, and the market appreciation to determine what constitutes marital property. Historical trends show that as the 401k became the dominant retirement vehicle, the complexity of divorce litigation increased exponentially. We saw the rise of the QDRO, or Qualified Domestic Relations Order. This is a highly specialized legal document that acts as a bridge between a state divorce court and a federal retirement plan. Without a QDRO, you cannot simply transfer 401k funds to an ex-spouse without triggering massive IRS penalties and immediate income tax hits. The creation of the QDRO was a turning point in American history because it acknowledged that retirement accounts are no longer just work benefits. They are the bedrock of communal family wealth. Consider a case study of a mid-career professional in the early 2000s. During the tech boom, their 401k might have been heavily invested in aggressive growth stocks. If that couple divorced during a market peak, the value of that asset was sky high. But if the legal process dragged on into a market downturn, the actual cash value of the split could change by hundreds of thousands of dollars before the QDRO was even signed. This volatility introduced a new layer of anxiety into the American divorce experience. It wasn't just about who got the house. It was about who got the basis and who got the growth. Furthermore, the cultural perception of the 401k has changed. In the 1980s, it was a novelty. By the 2020s, with the decline of Social Security's perceived stability, the 401k has become a survival fund. When a divorce occurs at age 55 or 60, a phenomenon often called gray divorce, the division of the 401k becomes a matter of literal survival. There is no time left to rebuild. If a spouse loses half of their $800,000 account, they aren't just losing money, they are losing their ability to stop working. This has led to a dramatic increase in the number of Americans over the age of 65 remaining in the workforce, not by choice, but because their retirement infrastructure was dismantled in a courtroom. We must also look at the psychological impact of this financial shift. For decades, the worker viewed the 401k as mine because it came out of their salary. The non-working or lower-earning spouse often felt a sense of insecurity, knowing they were dependent on an account they couldn't access. The legal battles of the last 30 years have been a slow, painful process of redefining ownership in the American household. The 401k divorce isn't just a legal procedure. It is a cultural autopsy of how we value labor, both inside and outside the home. In the coming sections of this deep dive, we will break down the specific math used by courts to determine the marital portion of an account. We will look at how loans taken against a 401k, a common move during marital strife, can create a tax nightmare during a split. We will analyze the specific ways different investment vehicles, from target date funds to individual stock options, are treated by the IRS when a marriage dissolves. This is not just about the law. It is about the evolution of the American family's balance sheet and the hard lessons learned by millions of people who thought their retirement was secure until the moment it was divided by two. Understanding this history is the only way to navigate the current landscape where the 401k remains both the greatest tool for wealth creation and the most significant point of contention in the American legal system. To truly grasp the magnitude of the 401k divorce phenomenon in 2026, we have to look at the mechanics of the shift from the era of paternalistic corporate responsibility to the era of radical individual accountability. For most of the 20th century, the American worker relied on the three-legged stool of retirement: Social Security, a company pension, and personal savings. But as that stool collapsed, leaving only the 401k standing for the vast majority of private sector employees, the definition of marital property underwent a seismic transformation. This shift created a specific legal friction point known as the commingling of assets, a concept that has ruined more retirement plans than any market crash ever could. Imagine a professional named David. In 2012, David started working for a major tech firm in Austin, Texas. He was single, ambitious, and immediately began maxing out his contributions. By the time he met and married Sarah in 2018, David already had $250,000 in his 401k. To David, that $250,000 was his premarital fortress. It was his sweat equity from years of late nights before he even knew Sarah existed. However, once the marriage certificate was signed, the math changed. Over the next 8 years, David continued to contribute, and the employer matched those funds. By 2026, the account had grown to $900,000 due to a combination of new contributions and the aggressive compound growth of the early 2020s bull market. Now, as David and Sarah navigate a divorce in 2026, the court doesn't just see a $900,000 account. It sees a complex chemical compound that must be distilled back into its original elements. The premarital $250,000 is generally considered separate property, but the growth on that $250,000 during the 8 years of marriage? That is where the legal battle begins. In many jurisdictions, the passive appreciation on separate property remains separate, but if any marital funds were used to manage it, or if the court follows specific equitable distribution rules, even that growth can be pulled into the marital pot. This is the first major trap of the modern era: the illusion of the premarital shield. Historical trends show that the 401k was never designed with divorce in mind. It was designed for tax deferral. Because of this, the IRS views the 401k as a single-owner vehicle. You cannot have a joint 401k. This individualistic structure creates a massive power imbalance during a divorce. While Sarah might have been the one managing the household or sacrificing her own career progression to support David's upward mobility, the account is legally in David's name and tied to David's social security number. To bridge this gap, the legal system had to create a sophisticated surgical tool, the Qualified Domestic Relations Order, or QDRO. Without a QDRO, David could not simply write Sarah a check for $450,000 from his 401k. If he tried, the IRS would view it as an early withdrawal. David would be hit with an immediate 10% penalty because he is under age 59 and a half, and the entire $450,000 would be taxed as ordinary income in the year of the withdrawal. In 2026 tax brackets, that could mean losing nearly half the value to the government before Sarah even sees a dime. The QDRO is the only legal mechanism that allows for the tax-free movement of these funds between ex-spouses. It instructs the plan administrator to carve out a portion of the participant's account and move it into a separate account for the alternate payee, usually the ex-spouse. But here is where the case studies get harrowing. The process of obtaining a QDRO is not a simple checkbox on a divorce decree. It is a secondary legal process that often takes place after the divorce is finalized. We have seen historical trends where a divorce is finalized in June, but the QDRO isn't drafted and approved by the plan administrator until December. If the market drops 20% in those 6 months, who bears the loss? Does Sarah get 50% of the value as of the date of divorce, or 50% of the value as of the date of the transfer? In the volatile economy of 2026, a 6-month delay in filing a QDRO can mean a difference of $100,000 in the actual capital received. Step by step, the division of a 401k in 2026 looks like a forensic investigation. First, the parties must obtain the plan's summary plan description to understand the specific rules of that employer's 401k. Some plans allow for immediate lump sum transfers to the ex-spouse, while others require the ex-spouse to wait until the participant reaches retirement age to see a single cent. Second, a valuation must be performed. This isn't just looking at the balance. It's identifying what portion is marital versus non-marital. Third, the QDRO must be drafted by a specialist. General practice divorce attorneys often outsource this to QDRO experts because a single misplaced comma can cause the plan administrator to reject the order, sending the parties back to square one. The cultural impact of this process has led to the rise of what sociologists call the silver divorce economy. Since 401ks take decades to build, they are largest for those in their 50s and 60s. In 2026, the baby boomer and Gen X populations are experiencing higher rates of divorce than previous generations at the same age. This means that at the exact moment these individuals should be transitioning into a low-risk, preservation-based financial strategy, they are instead forced to liquidate or split their primary engine of survival. Consider the scenario of Maria, a 58-year-old teacher who spent 30 years building a 403b, which is the nonprofit equivalent of a 401k. Her husband, Robert, worked in various startups that never offered a retirement plan. In their 2026 divorce, Maria's retirement account is the only significant asset besides their home. To keep the house, Maria might have to trade away 100% of her retirement account to Robert. Now Maria has a home with no liquid cash for property taxes or maintenance, and Robert has a 401k but no place to live. This trade-off, known as an offset, is a common potential outcome, but it often ignores the long-term tax implications. $1 in a house is not the same as $1 in a 401k. The house is bought with after-tax money, while the 401k is a ticking tax time bomb that will require 20 to 30% of its value to be paid to the government upon withdrawal. As we move deeper into this masterclass, we have to address the growing trend of 401k loans as a weapon of marital sabotage. In the months leading up to a filing, some participants attempt to drain the account by taking out the maximum allowable loan, thinking they can spend the cash or hide it before the assets are frozen. This creates a nightmare scenario for the legal system. Who is responsible for paying back a loan taken out during the marriage but used for personal gain? The complexity only increases when we factor in the modern workforce's mobility. By 2026, the average worker has had 7 different jobs by age 40, often leaving a trail of zombie 401ks at different institutions. Tracking down these accounts, valuing them, and issuing QDROs for each one is a logistical Herculean task that most people are completely unprepared for. But what happens when the 401k isn't just stocks and bonds? What happens when a self-directed 401k holds alternative assets like real estate or private equity? The valuation of these accounts in a divorce becomes a battlefield of expert witnesses and conflicting appraisals. In the next part, we are going to dive into the dark side of 401k valuations, including the specific tricks used to hide assets and the forensic tools used to find them. We will also explore the catastrophic tax trap that catches thousands of Americans every year when they try to settle their divorce without understanding the hidden math of the IRS. If you think a 50-50th split means you get half the value, you are about to see why that is the most dangerous assumption you can make. The reason a 50-50 split is a statistical illusion lies in the fundamental difference between pre-tax and after-tax dollars. In the American legal system of 2026, most divorce settlements are negotiated based on the current market value of assets, but this fails to account for the inherent tax liability embedded within a 401k. Imagine a couple, Michael and Jennifer, who are dividing their assets after 20 years of marriage. They have two primary assets of equal current value: a $500,000 savings account consisting of post-tax cash and a $500,000 401k. To the untrained eye, giving Michael the cash and Jennifer the 401k seems like a perfectly equitable distribution. However, this is where the tax trap snaps shut. Michael walks away with $500,000 in spendable liquidity. Jennifer walks away with an account that is essentially a joint venture with the Internal Revenue Service. Every time Jennifer withdraws $1 from that 401k in retirement, she will owe federal and potentially state income tax at her future ordinary income rate. If her effective tax rate is 25%, her $500,000 asset is actually only worth $375,000 in purchasing power. This $125,000 discrepancy is a silent transfer of wealth that occurs because the settlement focused on gross value rather than net value. Historical trends in high-net-worth divorces show that savvy negotiators now insist on tax affecting these assets, meaning they discount the value of the 401k by the projected tax liability before the split occurs. Beyond the tax math, we have to explore the dark art of the 401k loan, which has become a primary tool for financial maneuvering in modern American divorces. By 2026, the rules allow participants to borrow up to 50% of their vested balance or $50,000, whichever is less. In many case studies, we see one spouse, sensing an impending separation, taking out a maximum loan to pay for personal expenses, legal retainers, or even to move cash into untraceable avenues. This creates a massive complication for the QDRO process. If the 401k is worth $200,000 but has a $50,000 outstanding loan, the plan administrator sees the total value as $200,000 because the loan is considered an asset of the plan. However, the actual liquid balance is only $150,000. If the court orders a 50% split of the $200,000, the plan might attempt to move $100,000 to the ex-spouse, but there is only $150,000 available. If the borrowing spouse defaults on that loan during the divorce process, the unpaid balance is treated as a taxable distribution. This triggers an immediate tax bill, and if the borrower is under 59.5, a 10% early withdrawal penalty. Suddenly, the non-borrowing spouse finds their expected settlement diminished by the tax consequences of a loan they never authorized and never benefited from. This is why forensic accountants in 2026 now start every investigation by demanding the loan history of every retirement account involved in the case. Now, consider the complication of the market timing game. American history is littered with stories of couples who agreed on a dollar amount for a 401k split, only to have the market crash before the paperwork was finalized. Imagine if Michael and Jennifer agreed on a $250,000 transfer from Michael's 401k to Jennifer in early 2026. The 401k was worth $1 million at the time, so they filed for a 25% transfer. But then, a period of global economic volatility causes the account to drop to $700,000 before the plan administrator processes the QDRO. Does Jennifer still get $250,000, which would now represent over 35% of the account, or does she get 25% of the new lower balance, which is only $175,000? The specific language in the divorce decree determines the potential outcome. If the decree specifies a fixed dollar amount, the person holding the account bears all the market risk. If it specifies a percentage, the risk is shared. In 2026, we are seeing a shift toward more sophisticated QDRO language that includes earnings and losses on the awarded share from the date of separation until the date of distribution. This ensures that the non-employee spouse is treated as a true co-investor in the account rather than just a creditor. There is also the cultural phenomenon of the forgotten 401k. Because the average American worker changes jobs every few years, many people reach the point of divorce with a trail of small, neglected accounts from previous employers. Step by step, the discovery process must include a thorough search of old tax returns and W-2s to find these zombie accounts. In many case studies, a spouse might intentionally fail to disclose a $15,000 account from a job they held a decade ago. While $15,000 might seem small compared to a primary 401k, when compounded over another 20 years, that account could represent a significant portion of a person's future security. Failure to disclose assets, even retirement accounts, can lead to the court reopening a case years later and awarding the entire undisclosed asset to the other party as a penalty for fraud. The 401k also presents a unique challenge in the context of the gig economy and the rise of the solo 401k. By 2026, millions of Americans are self-employed or run small LLCs, utilizing solo 401k plans which allow for much higher contribution limits than traditional corporate plans. In these cases, the person participating in the plan is often the one reporting the income and managing the investments. This creates an environment where it is dangerously easy to manipulate the value of the account. A business owner might delay a large contribution or artificially depress their income in the year leading up to a divorce to make the 401k look less robust than it actually is. We must also discuss the role of the plan administrator as the gatekeeper. Many people assume that if a judge signs a divorce decree, the 401k is automatically split. This is a catastrophic misconception. The plan administrator, who works for the employer or a third-party financial institution, is bound by federal ERISA law, not state divorce law. If the judge's order asks the plan to do something that is not permitted by the plan's specific rules, such as transferring money to an ex-spouse before the participant is vested, the plan administrator will simply reject the order. This leaves the ex-spouse in a legal limbo where they have a court order but no way to collect the funds. In 2026, the best practice is to submit a draft QDRO to the plan administrator for pre-approval before the judge ever signs the final divorce decree. This structural rigidity of the 401k system has transformed divorce from a negotiation of needs into a battle of administrative compliance. It is a world where being right on the facts doesn't matter if you are wrong on the paperwork. The cultural history of the 401k divorce is characterized by this tension between the messy, emotional reality of a relationship ending and the cold, binary logic of the tax code and retirement plan bylaws. As we look toward the future, we are seeing the emergence of new technologies that allow for the automated discovery of retirement assets, but these tools also give rise to more sophisticated ways to hide them. The next evolution of this struggle involves the intersection of 401ks and digital assets. By 2026, some forward-thinking 401k plans have begun allowing participants to hold a percentage of their portfolio in cryptocurrency or tokenized real estate. This introduces a level of volatility and valuation difficulty that traditional QDROs were never built to handle. How do you split a 401k that contains a fluctuating amount of Bitcoin or a fractional share of a commercial building in a way that is truly fair and accounts for the massive swings in value that can occur in a single afternoon? In the next part, we are going to explore the high-stakes world of executive 401ks and the secret world of non-qualified deferred compensation plans. These are the shadow 401ks, used by the top 1% of earners, and they follow an entirely different set of rules that can make or break a high-asset divorce. We will reveal how these plans are often hidden in plain sight, and the specific questions you must ask to uncover millions in deferred wealth that traditional discovery often misses. If you think a standard 401k is complex, you haven't seen anything yet. The shadow world of executive retirement is where the standard rules of the 401k go to die. In the upper echelons of corporate America in 2026, the 401k is often just the tip of the iceberg, a modest entry point compared to the massive wealth hidden in non-qualified deferred compensation plans, often referred to as NQDC plans or top hat plans. These are the financial engines that power the lifestyles of the top 1% of earners, and they operate under a completely different set of historical trends and legal precedents than the accounts used by the average worker. If a standard 401k is a transparent glass box, an NQDC plan is a lead line vault buried beneath the corporate headquarters. To understand why these are so difficult to divide in a divorce, you first have to understand what they actually are. Unlike a 401k, which is a funded account held in a trust for the benefit of the employee, an NQDC is essentially an unfunded promise from the employer to pay the employee at a later date. This distinction is vital, In the eyes of the law, the money in a top hat plan doesn't actually belong to the employee yet. It is a liability on the company's balance sheet. If the company goes bankrupt tomorrow, the executive becomes an unsecured creditor, and that retirement money could vanish. In a divorce case study involving a high-ranking executive named Richard in 2026, his standard 401k might show a balance of $1.2 million, but his NQDC statement might show a projected future value of $8 million. Because these plans are non-qualified, they do not have to follow the same fairness rules as a 401k. An employer can offer them to whoever they want in whatever amount they want. More importantly for our purposes, they are not governed by ERISA. This means you cannot use a standard QDRO to split them. You are stepping out of the streamlined world of federal retirement law and into the Wild West of contract law and state-level equitable distribution. When Richard and his spouse, Amanda, decide to part ways, the $1.2 million 401k is easily split via a QDRO. But the $8 million in the NQDC plan requires a separate, far more aggressive legal strategy. Imagine the complexity of valuing a promise that hasn't been fulfilled yet. Richard's $8 million is contingent on him staying with the company until a certain age or reaching certain performance milestones. If Amanda wants her half now, how do you value a future payment that might never happen if Richard gets fired or the company fails? This leads to a high-stakes negotiation where forensic accountants must calculate the present value of future benefits. They look at historical trends of company stability, the likelihood of the executive reaching their vesting milestones, and then they apply a discount rate to account for the risk and the time value of money. In many 2026 case studies, we see spouses forced to choose between a smaller immediate cash buyout or a larger percentage of a future payout that carries the risk of never arriving. Furthermore, we have to talk about the Supplemental Executive Retirement Plan, or SERP. These are often structured to provide an executive with a specific percentage of their final salary for the rest of their life after they retire. In the context of an American divorce, a SERP is a nightmare because it looks like a pension but behaves like a private contract. If the divorce occurs while the executive is still working, the court must decide if the non-employee spouse is entitled to a portion of a benefit that hasn't even been calculated yet. We often see the use of a formula known as the coverture fraction. This is a step-by-step mathematical breakdown where the court divides the number of months the couple was married while the executive was in the plan by the total number of months the executive was in the plan. That fraction is then applied to the eventual benefit. Step by step, the discovery process for these shadow accounts is grueling. A standard subpoena for financial records often misses them because they don't appear on typical 1099 or W-2 forms in the same way. You have to look for the nuances in the executive's employment contract. You have to analyze the company's proxy statement or 10K filings if it is a public company, looking for specific disclosures about executive compensation. In many instances, the spouse isn't even aware these plans exist. They see the 401k statements arriving in the mail and assume that is the extent of the retirement nest egg, while the true wealth is accumulating in a ledger deep within the HR department. A critical potential outcome in these cases involves the tax consequences of a split. Since NQDC plans are not qualified, you cannot roll the money into an IRA tax-free. If the court orders a distribution from a top hat plan to an ex-spouse, it is often treated as a cash payment that is fully taxable as ordinary income to the executive. This creates a friction point. If Richard has to pay 40% in taxes to give Amanda her share, he is going to fight much harder to reduce that share. The 2026 legal landscape is shifting toward requiring the non-employee spouse to share in that tax burden. But the mechanics of how to do that without a QDRO are clunky and often lead to further litigation. Let's look at another layer. Restricted stock units and performance shares. In 2026, many executive 401ks are supplemented by equity grants that vest over time. These are frequently treated as part of the retirement package. Imagine if Richard was granted 50,000 shares of a high-growth AI firm in 2023, but they don't fully vest until 2027. If the divorce is finalized in 2026, who owns the shares that haven't vested yet? Some courts use the time rule, which treats the shares as a form of deferred compensation for work performed during the marriage. Others view unvested shares as a mere expectancy of a future gift, making them separate property. The difference between these two interpretations can be worth millions of dollars. The cultural history here is one of increasing opacity. As the 401k became more regulated and easier to split, corporations found new ways to compensate